Okay, today's lesson is on workplace discrimination. And the vocab for today, discrimination, we are using it as making business decisions based on someone's protected class. And a protected class is defined as a certain person's characteristic that has to be recognized and protected by law. Not everything about you is protected by law. Okay? Businesses can make decisions based on things about you, and it's legal unless it's a characteristic recognized and protected by law. The unit we're going into is Discrimination, Harassment, and Sexual Harassment unit. This lesson is on the definitions and the coverage of workplace discrimination, and future lessons will go into the legal considerations of discrimination, how it is prosecuted, and the consequences of. Now, an overall note to make to simplify everything, there are so many technical issues with workplace discrimination that here is your best advice. If you're an employer, assume that it's discrimination and don't do it. So if you ever have a question, is this a discrimination? Well, the first thing to do is not do it until you do your research. Protect yourself. So don't do it don't make the decision until you determine if it's legal. If you're an employee, don't assume and you know nothing, don't assume every decision your boss makes is discrimination. Research it first to see if it could be. Okay, so if you're an employee and know nothing, research first, don't assume. So the process of anti-discrimination laws in the United States is a long journey. And the question should be, what is it about the United States that would promote anti-discrimination? Another way of saying it is all of history, in basically everywhere, discrimination was legal in business. That is the normal of history. So what in the United States, and why did the United States produce anti-discrimination laws? And where did this idea that in business people shouldn't be discriminated against, where did that idea come from? And that's an interesting question to examine, because it certainly wasn't all of the United States history. And in fact, the thoughts of discrimination in the workplace is wrong is a fairly recent, in the last 80 to 100 years in the United States history. So to delve into that question, we have to go back to the founding principles of the United States and why those founding principles are different than the founding principles in virtually the majority of all other countries in history. And so we go back to the United States, the early years. Now, the United States as a nation was founded in 1776 with the Declaration of Independence, where the basic ideas of the country were spelled out. And the United States started as an independence movement. And very, very, very clearly, this independence movement and the eventual Constitution of the United States was based on a movement going on at the time in Europe called the Enlightenment. Revolutions are based on many different ideas, such as the Communist Revolution in Russia. The Russian Revolution was based on communism. The French Revolution and the American Revolution were based on the movement of the Enlightenment. So we have to go and we examine what is at the heart of this movement in the 1600s and the 1700s, the Enlightenment movement in Europe. Well, at its heart is a rejection of the nobility and absolute kings. The Enlightenment was about the sovereign individuality and liberty of the individual. So people had inalienable rights. People had rights. Families had rights. And the government was only an agreement formed by the people to protect people's liberty and equality and fundamental rights. And that government-people contract was the social contract. Now, it is important to note that looking back at the 1700s Enlightenment, when we're sitting in the 2000s looking back at the 1700s, many people would assume that the Enlightenment ideals of the 1700s were incomplete because they used words such as equality and liberty. But in practice, in the very early parts of Enlightenment governments in France and the United States, that equality and liberty did not extend to the sexes, did not extend to nationalities, to races. Okay? So today, looking back at the ideals of the Enlightenment of freedom and liberty, it would be judged as incomplete. Now, back at the time, even incomplete, these ideas of individuals having rights and even some people having equality were revolutionary to the thoughts of humanity and how society had been through the generations and the millennia. So anti-discrimination did not occur at the founding of the United States, okay? Businesses did discriminate. Now, granted, there were a lot less businesses in 1800. Big business with lots and lots of employees was much more of an industrial revolution thing, okay? But even during the Great Industrial Revolution, with hundreds and thousands of employees, these businesses could still discriminate, okay? So anti-discrimination was not one of the founding ideals of the Enlightenment. It was much more, at the beginning of the Enlightenment, it was much more someone's right to their own property. John Locke said right to life, liberty, property. In the United States, changed it to life, liberty, and pursuit of happiness. But this idea of individual property, your own labor, and the right to control your own business, that was seen as a fundamental Enlightenment idea. So at the beginning of the country, it was much more on the right of the business owner. The business owner had more rights than the minority individual or basically any individual. So the rights of the business owner was seen way up here as opposed to any other ideas or rights. And we could see that that's one of the reasons that the U.S. at the time of the founding and until the Civil War had slavery as an institution. And we see tons of discrimination. You name a class, and there was discrimination about it. Women were discriminated in the workplace. The Irish, every wave of immigrant came over after the United States started in 1776 and was discriminated against. We see that discrimination. Children were put into the workplace, okay, for gosh sakes. Children were allowed to work up until, through the 1800s, okay? So these ideas of the right to control your own business without government interference was at the heart of Enlightenment ideas of freedom. But then it changed. See, freedom, liberty, equality is a continually changing idea of what society deems as when we have different individual competing rights against each other. And for lack of a better, more specific idea, in the mid-1900s, and you could go back to the early 1920s and 30s, but let's just say the mid-1900s, very recently, the Enlightenment idea of equality and the actual words of the Declaration of Independence, all men are created equal. Okay, those two ideas of equality and created equal, they started to mean something more important than, well, not more important, different than individual rights and business rights. It started to mean the right to freely participate in the economy without discrimination. Okay, people started seeing, like, if they started focusing in on the Enlightenment idea of all men are created equal, and then it became all women are created equal, and all people are created equal. And that didn't fit. If all people are created equal, how come they're not equal in the workplace? How come businesses can treat American citizens different based on how or where they're born? So that idea of created equal started meaning you can have equal and free participation in the workplace. And that right became greater than the business owner's right to decide whom to hire or whom to promote and how to pay people. Look, this is not a bug in the system. This is a feature of the system. This is baked into the system of rights. Whenever you have multiple rights, those rights will come into conflict, okay? This is a normal thing when societies value the different rights. There is not unlimited freedom of speech. There is not unlimited freedom of religion, okay? Freedom of speech, freedom of religion have to be valued on other people's rights, okay? Freedom of speech has to be valued on someone's right not to be threatened. We are always valuing rights in addition to each other. This is a feature of rights of the system. It's not that it was wrong in the beginning. It was, in this particular case, it was that the right to control one's own business was being valued higher than someone's right to participate in the economy without discrimination. At the time, that's how they ordered the rights. And then as the country progressed in time, the rights got reordered. The country learned that the majority of people didn't want to live in an economy with discrimination. And so giving business owners the ultimate right to discriminate and the right to their own business, people realized they didn't like the society that created. It created a discriminatory business society. And so that's why they reordered the rights and we get anti-discrimination laws. This is part of the system and how the system reorders itself. And it works that way because the system is founded on rights of the citizens. And we are continually ordering the rights of the citizens with the power of government and the other rights of citizens. And so in the mid-1900s, we start getting the idea that non-discrimination in the workplace became a more preferred right than a business owner's right, although it's still imbalanced today. And there's a second argument towards why we're moving towards anti-discrimination in the workplace. And quite frankly, I think this one should have started in the very beginning of the United States. I think this is self-evident, to quote a phrase. I think this one should have started at the beginning. One of the reasons I think it didn't really start is that early United States government didn't have a lot of jobs. The early U.S. government didn't employ a lot of people, so there wasn't a lot of opportunities for there to be discrimination or not discrimination. Now we have like 30% of the workforce or 30% of the economy, according to some studies, are under public employment by the government. So now it seems much more important. Follow me here. Whenever has it fit into the founding ideas of America that a government has the right to discriminate against its citizens, okay? That's like exactly the opposite of the Declaration of Independence, the ideas of the Enlightenment, okay? An all-powerful government that sits and discriminates against people? To me, that seems like that should be negative since the beginning, but it took until the 1900s for the United States governments to stop discriminating or start the process of not discriminating in the jobs, okay? And I would challenge you. I do believe lots of people can have an argument of business owners' rights versus rights of the workers, okay? But I challenge you. How do you justify the government, which is not a private family, which is not a private business? How do you justify the all-powerful state, local, and federal governments? How do you say it's okay for them to discriminate in employment? Because that's the government. It's not a family. It's not the rights of a business owner. So I think we're on very, very firm Enlightenment anti-discrimination ground when we say that the government does not have a right to discriminate, no matter what you think the rights of the business owner is. The government is the owner of the business for many millions of workers in America. And I question you, what foundation does a government have to discriminate? So that would say the government should be an anti-discrimination right there. So where are we today? Through many acts of Congress, okay? It's not just one act in the 1960s. It's through many acts over the years, okay? Many anti-discrimination laws have been put into business where businesses can't make decisions based on certain protected classes. Today, the government employees and businesses that get money from the federal government very much cannot discriminate. You'll see many things are protected, okay? So government employers, and businesses that get money from the government. This was from that second idea where there's no real justification where we can say that the federal government or governments should be able to discriminate. It just doesn't fit in with what this country is all about. So government employers plus businesses that get money from the government can't do discrimination. And for private businesses, it is still a balancing act, okay? We are still balancing the rights of an owner to make decisions for their own business versus the rights of individuals not to be discriminated against. It's still a balancing act. So there's two main ways that we as a society and our laws have come up to balance those two rights. And the number one is the sphere of power. A compromise has been made. The federal government, the awesome power of the whole United States federal government, only regulates business with anti-discrimination of greater than 15 employees. So the compromise is, if you have a very small business of only 15 or less employees, the federal government says you could do basically what you want. it's not going to affect the economy that much. So the federal government isn't going to get involved. And I mean, to be fair, this is a little fair. Do you really want the awesome power of the whole federal government and the FBI and everything like that? Do you want that focused in on small little family businesses? It's an interesting balance. Now, the federal government says, well, we can leave it up to the states because the states can have lots of power too. So the states can make extended protections. So the federal government only regulates bigger businesses in certain areas and they leave it to the states. So if you have a state that says we want to add more protection and we want to regulate smaller businesses, then we can do that. So the states have that choice. And you should make a note. New York has many anti-discrimination laws. So the best thing to do is never to even think about discriminating in New York. So it might not break some federal laws, but then there's the additional state of New York laws. Now, some would say, why does the federal government get involved in any business? Because certain businesses are so large that they have national impact. Whether the cutoff 15 employees is right or not, that's up for debate. But there is no debate that certain businesses are so large between states too that the federal government has a right to regulate. So the second balance between the rights of a business owner to make their decisions and the rights for non-discrimination is to limit what's discrimination and what's not. And the way this has come about over the multiple years is that there are protected classes. Okay? There are certain characteristics recognized and protected by law. Not everything is protected. If you like a certain music and your boss finds out you like that certain music and your boss doesn't like you because of it, they can fire you and you don't have a lawsuit. That's not protected. That's not discrimination. Your choice in music is the boss has the right to run their business and say, I don't want people who listen to this music working for me. That's not discrimination. You see, the characteristics usually came from two different things usually had to happen. Number one, a characteristic is usually something that was historically discriminated against, okay? Such as race, color, sex, age over 40. Historically, through the history of the United States, many people over 40 were discriminated against and fired and not hired. Women were discriminated against and not hired for certain jobs. Men weren't hired for certain jobs. Okay? There was a history of discrimination against certain classes. And so it was deemed as a problem to be fixed by protected classes. And the second thing is it's usually not a choice. Protected classes are usually not, they're part of how you're born, who you are. That's not a choice. And so the government gets that combination of saying, if you have no control over it and it's not historically been, or it has historically been a problem, it's going to be called discrimination and we're going to outlaw it and make it illegal. Okay, so your choice of your music preference. Number one, it hasn't been a problem in America. So discrimination based on music liking, why write that into a law if it's never really been a problem? And two, it's a choice. Okay, it's literally a choice that if you like this kind of music, that is something you have chosen. It's not really deeply who you are. And the business owner just has the right to surround themselves with people who like certain music. Simple as that. And even though we mentioned that it's historically, the law protects typically minorities, it turns out, once they make the law of no discrimination, everyone is protected, okay? If they say no discrimination based on religion, it doesn't just mean the 5% religion, it means you can't discriminate against the 95% religion, okay? So Christian is the majority religion in the United States. You cannot make business decisions based on someone's Christianity, even though they are in the majority. Even though historically it was other religions that were discriminated against, all religions are protected, just like all races. We are all protected classes. We all fit into protected classes. Here are the classes the federal government has issued, period. Race. Whatever you think race means, it's protected. Color. Someone's hue and skin tone. Cannot make business decisions based on race or color. Someone's religion. All of these are protected. Can't make business decisions based on these. Someone's national origin. Where they were born. Someone's sex. originally meant male or female, later extended to pregnancy, if you're pregnant, later extended to sexual preference, whom you're attracted to, and recently extended to your gender expression, whether you're trans or not. All of those are federally protected. Age plus 40. Disability, both mental disabilities and physical disabilities. And genetic info. Now, genetic info is the markers of your genes and your predisposition for medical diseases or your medical history, okay? So your medical history, your genetic info can't be discriminated against. That would come up in a job interview if a business doesn't want someone predisposed to a cancer or something to save on insurance, okay? They can't do that. Or if someone, would take a lot of sick time, they can't ask you for your medical history, genetic info. And if it's the government jobs only, your political opinion. Your political opinion is protected. That's under freedom of speech. But if you're not working for the government, watch out who you put a bumper sticker on your car for, because you could be fired immediately if it's in the private sector for your political opinion. No questions asked. So I'd like to talk finally about what protections people have for the anti-discrimination laws. Okay, so at work, if it fits into the categories, businesses can't use protected class status to influence anything to deal with hiring, firing, promotion, basically any work-related decisions, whole or in part, even if it's just a little bit of the reason why a decision would be made and it's made on a protected class. That's illegal discrimination. Even if the business thinks it would make them more money, they just don't have that right. 2, if you as an employee complain about possible discrimination, the business can't then retaliate against an employee if the employee accuses or complains. This is called retaliation and it's illegal. So if the employee thinks there's discrimination going on, they have a right to bring it to the authorities to make a complaint within the business, and they are free from negative consequences. And finally, this anti-discrimination transfers over to customers. The business cannot choose or deny customers based on a protected class. It's just not legal. So those signs that say we have the right to refuse service to anyone, those are absolutely 100% not true. There are certain reasons you cannot refuse a customer, and that is based upon their protected class. Now, there are some exceptions to this, and we'll go over some of them at a later date. But they are special cases. These are the in general. The in general, you can never be wrong if you follow these anti-discrimination ideas. There are plenty of special legal cases, okay? This is the United States. There are literally feet and miles. There are literally tens, if not hundreds of thousands of pages of rules and regulations. There's always special cases. This is the, in general, anti-discrimination laws. Thanks for watching.